I hate to disagree with the good chair of the Labor Committee, but I don't see this amendment as a technical amendment at all. It does three separate changes to the language of the bill. The first and third one I'm less concerned with, but the middle change, which says in line 85, strike the words "and if possible" from the language of the bill, is a substantive policy change, and I think a very significant one. Before I get into what my perception is, let me ask the chairman if she, through you, Madam President, how she sees this language changes the bill and why she would characterize it as simply technical. Through you, Madam President.
Senator Kushner.
Thank you, Madam President. In this section of the bill, it provides that the employer will provide information applicable to the collective bargaining unit to the collective bargaining agent, and it says that the file format agreed to by that the exclusive representative in it will get the information in editable digital file format agreed to by the exclusive bargaining representative. And it lays out the various points of information that they would be required to provide to the union.
Senator Sampson.
Thank you, Madam President. I appreciate the reading of the language in the bill, but we didn't get to the point of the amendment, which is the omission of the term "if possible." What technical change is made there? Through you, Madam President.
Senator Kushner.
This actually just says that you must provide all of this information, and that is, if possible, is superfluous because, in fact, the employer is in possession of all of that information.
Senator Sampson.
Thank you, Madam President. I appreciate that answer. I would not characterize that as superfluous personally, because essentially what we are doing is making a significant policy change from suggesting to the municipal employer or the state employer that they must provide this information only if possible. And by removing the term "if possible," we are creating a mandate that suggests that they have to provide this information. That's the first point, which I believe that's a substantive change. Because when someone asks me to bring them $1 million if possible, I don't feel obligated. But if I have to do it, that presents a little bit more difficulty. And that's what's going on here. We're making a substantive change. So I would just be careful about characterizing an amendment that really makes something that's very substantive as merely technical, because I don't believe anyone would say that that is a technical change if they really analyze the difference in policy. But the second part of my concern about this is that I believe what's happening here is we're actually creating a substantial problem and a conflict with another statute. There is a statute that we currently have on the books, which is Section 31-128F of the Connecticut General Statutes. And I will just read the highlights of it, which basically says that employees' consent is required for disclosure. It says no individually identifiable information contained in the personnel file or medical records of any employee shall be disclosed by an employer to any person or entity not employed by or affiliated with the employer without the written authorization of such employee. And it does have an exception, and that exception is a couple of different things. The only one that's relevant to the bill, though, is number 6, which is where the information is disseminated pursuant to the terms of a collective bargaining agreement. And the reason why I ran into this statute is because I was actually looking at some collective bargaining agreements, Madam President, and I was looking at the Attorney General's office and their collective bargaining agreement, and discovered this language, which I believe is in direct conflict with this bill if this amendment passes. Because on one hand, we're suggesting in the existing statute which remains unchanged by this bill or amendment, that says that no employee information can be disseminated or shared without written consent or as part of a collective bargaining agreement. And what this language would change the existing or create a new law that is in direct conflict. So we would end up with two laws, Madam President. We would end up with one law that says you can't do this unless you have it in a collective bargaining agreement, and you would have another law created today if this amendment and bill passes, which says that this information could be required and not, if possible, as a mandate. So I have a question through you, Madam President, for the proponent of the bill. I'd just like to ask the chairwoman what she thinks about this situation, and how do we address the fact that we would end up with two conflicting statutes in our laws? Through you, Madam President.
Senator Kushner.
I feel this is within our rights as a legislature to make a law that says that under these circumstances of collective bargaining, in this case, new employees would be, the public employer would be required to provide this information to the union. And I don't think the fact that two different statutes say two different things is a problem. So I don't think this would create any conflict. And I think, in fact, if there was a conflict that should be of concern, we would have been notified by OLR of that. Thank you, Madam President.
Senator Sampson.
Thank you, Madam President. I appreciate the answer, but again, I have to disagree. I don't believe it is within our purview to be creating conflicting laws. I think laws are only relevant, and I think this is a consistent part of our system of laws and justice, and a something that comes up in lots of judicial arguments and debates about whether or not there is clarity to the public on what our laws actually are. So I disagree completely that you can have two conflicting laws passed and enforced at the same time. Madam President, through you, would the chairwoman suggest that one of these laws take precedent over the other? Through you, Madam President.
Senator Kushner.
I think this law is the statute before, the bill before us is very clear that in the instance where there is a collective bargaining agreement, then the public employer would be required to provide this information to the union representatives. And I think that's very clear, and it would be no conflict and would be required of any public employer.
Senator Sampson.
Thank you, Madam President. Again, I appreciate the answer, and it looks like I'm not going to get anywhere here. I am sincerely trying to bring up a genuine concern about how we're passing this law. It's not even a suggestion of whether I agree with this policy or not. I believe that when we pass legislation through this chamber and pass it into law, we owe it to our constituents to make sure that it is completely clear to them what the law is. And it is my assertion, and I'd like it for the record, that if this amendment passes and this law or this bill ultimately becomes law, it will, in fact, become in direct conflict with Section 31-128F. And that's on the record right now. So I would leave it up to folks in the future to make use of that information for whatever purpose necessary. And I suppose we'll move on. I will encourage my colleagues to vote against the amendment before us, because I do believe it creates an additional and substantial mandate on municipal employers and the state, and therefore a burden that might result in higher taxes, higher property taxes, and so on. And I believe it creates the conflict that I mentioned a moment ago. And if it has not already been asked for, I'd like a roll call vote. Thank you, Madam President.
And a roll call vote will be ordered on the amendment. Will you remark further on the amendment that is before the chamber? Senator Kushner.
Thank you, Madam President. And forgive me. Thank you, Madam President. And forgive me for getting up a second time. I'll be very brief. I just wanted to follow up on a comment that the good chairman of the Labor Committee made just before encouraging support of the amendment. And I want to also take a moment just to thank my colleagues for standing up in agreement with me that this amendment is far more than a technical change. I think anyone that looks at it fairly will see that this is a significant policy change. My concern was that she mentioned that the union is affiliated, I believe was the term she used, with the municipal employer. And I take umbrage to that. I don't think that's an accurate depiction. I believe that these entities are often in close proximity, and they negotiate with one another, but I don't believe they would be characterized as affiliated in any way. And further, if you were going to make that argument and suggest that the statute I referenced earlier, which is 31-128F, which the good chairman said is what allows this to not be a conflict, because those that are affiliated with the employer are able to give out this employee information without consent. And I would just simply say, if that's true, then there's no reason for the bill before us, Madam President, because you've already created that in the other statute if, in fact, you consider the union an affiliate of the employer. So I'm confused. Either way, there is some confusion and a conflict here. And I just want to mention that that is not the only conflict that exists in our current statutes. That is a labor relations statute. But if you look in the FOIA statutes, you'll find yet another one, which is Section 1-217, which is about the non-disclosure of residential addresses of certain individuals. And if you go to Section E, it says no public agency or public official or employee of a public agency, that would certainly cover a municipal employer, shall be penalized for violating a provision of this section unless such violation is willful and knowing. And clearly they'd be willful and knowing, because they would be doing it pursuant to this new statute. And it says if the commission finds that the public agency, official or employee willfully and knowing violated a provision of this section, the commission may impose against such agency, official, or employee a civil penalty of not less than $20, no more than $1,000. And I presume that is per instance. And that could end up being a substantial amount of dollars that a municipal employer might be faced with. So I just want to leave us on this debate on this amendment. Number one, I will repeat, this is no way a technical amendment. It is an incredible change to the underlying bill by making something that was optional mandatory. And what it's making mandatory is the dissemination of people's private information by someone who doesn't probably want to even give it out for a purpose they may not agree with, and in direct conflict with other statutes on the books. Again, everyone should vote no on this amendment. Thank you, Madam President.
Thank you, Senator Sampson. Will you...
Have all the members voted? Have all the members voted? Please check the machine to make sure that your vote is properly cast. Mr. Clerk.
Senate Bill 90A, Senate Amendment A, total LCO 8219, total number voting 34, total voting yea 21, total voting nay 13, absent not voting 2.
The amendment is adopted. Thank you, Mr. Clerk. Will please proceed.
Thank you very much, Mr. President. I appreciate the recognition. And now that we've gotten the amendment out of the way, we can focus on the bill as amended. I want to just point out that I appreciate the title change. This bill is entitled An Act Concerning Access to Certain Public Employees by the Exclusive Bargaining Representative of a Public Employer Bargaining Unit, which is an appropriate title since that's what the bill does. The original title of the bill was An Act Concerning the Right of a Public Employee to Join or Support a Union, which I don't believe is in dispute, and had absolutely nothing to do with the language in this bill, since I don't believe this bill supports the rights of public employees in any way, shape, or form. In fact, I think it does exactly the opposite. Before I get really into talking about the language in the bill, I just want to make it very, very clear where I'm coming from on this proposal, which is that I'm very much in favor of freedom in every respect, and that includes the ability to assemble and to join together and to collectively bargain for rights. My only consideration when it comes to policy that has to do with union organizing, collective bargaining, and that type of subject matter is simply that we write public policy that is moral, just, fair, and right. I think almost every bit of policy that we work on in this chamber can somehow be boiled down to freedom versus force. And this particular bill is a lot about force. It is about the force of our state government creating laws that are unfair to participants in what should be a free arrangement to engage in negotiations and agreements. And I believe that this policy before us is extremely dangerous because it is removing that freedom from the equation and replacing it with the force of government to negotiate on behalf of one of the parties. It's actually very confusing because it just so happens that it is the government itself that is essentially creating a more of a weight on the scale of the opposing force from government in a collective bargaining negotiation. It's very interesting. I'll just simply state from the outset that I think this bill is a brazen disregard for the rights of employees, not to mention municipal employers across our state. And I believe it's intended to purposefully circumvent a Supreme Court decision from 2017 known as the Janus decision. This bill limits the rights of workers. It does not expand on the rights of workers. It limits the rights of workers, and I want that to be extremely clear that this bill could be only described as against employees, because in every case, when it comes down to what the employees' rights are in this legislation, they don't have any. Their information is going to be given up regardless of their wishes. And finally, these type of policies will raise taxes. Certainly, when you have unionized labor in a public employee setting, it creates higher wages and we pay higher taxes as a result. But this particular bill is going to expressly impact municipal employers in a significant way, which is going to drive up the cost for each of our towns to do business, and therefore drive up our property taxes, which are some of the highest in the entire country, and a reason why many people are fleeing this state. Certainly there are people coming here also for different reasons, but that doesn't change the fact there are many people who are analyzing what the cost of living in our state is every day and making a choice to relocate. So I want to talk about some of the language in the bill. The very first section basically says that a public employer shall provide an exclusive representative, which we're referring to the representative of the collective bargaining agency, the following information on newly hired employees: the name, the job title, the department, work location, work telephone number, and home address of any newly hired employee. I think this is a very interesting section because we just debated the amendment at some length, and the amendment had to do with folks that are already members of the union. And this is referring to folks who have not made a decision to join the union or not. And yet we are asking in this legislation, right in Section 1, the very first part, to force a municipal employer, whether they want to or not, to give up this person's information, whether that person wants it given up or not, to the union organization. And obviously that's for the purpose of having the information to encourage them to collectively to join the union and have the union work on their behalf. My objection to that is not that I think any of those things are bad, but they should be the personal choice of all the parties involved. The employee should be the one that makes those decisions, and not this body by force rather than freedom requiring a municipal employer to give it up. So on line 22, there's a sentence that says, each public employer shall, not may, provide the exclusive representative access to its new employee orientation. So this is even beyond the information, now they are saying that we need to allow someone who represents the union into an orientation for new employees. The public employer shall give the exclusive representative not less than 10 days written or electronic notice in advance of such an orientation. So through you, Madam President, what is the purpose of this section? Why does the exclusive representative of the union need access to new employee orientations? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. Through you, it has become very clear that in sort of the history of collective bargaining and in negotiating contracts, I myself have had this experience where it becomes very clear and obvious that oftentimes employers will have an orientation, and the purpose of that orientation typically is to go through what the terms and conditions of employment are, the kinds of benefits you're going to get, the options you have, the procedures of the workplace. And, that's good that new employees would get that information in a group setting often, especially where there's an employer that has a high turnover or is often hiring a lot of new employees. It's useful to do it in that kind of an orientation setting. And over the years, it's become very clear that that's a very good and appropriate time for a union representative to explain what's been negotiated in the contract. And oftentimes there are benefits that are provided to the employee that the union can best describe. And so it's really typical in union contracts to have access to orientation. I think here in this statute, what we're saying is we want to make sure that when there are orientations for new employees in the public sector, we want to make sure that the union has access to that in order to make clear to the employees what the benefits of being covered by that collective bargaining agreement would be. And so they can make a good decision based on information they receive there.
Thank you, Senator. Will you remark further? Senator Sampson.
Thank you, Madam President, and I appreciate the chairwoman for that answer. Clearly, that new language that is in this bill and this particular section that we're referring to is certainly going to be a benefit to the exclusive representative and the union that they are there on behalf of. But what is the benefit to the employer, since it's the employer that is the one who is providing the access? I guess that is what is lost on me in this equation when you put this type of thing in the law. This particular body, and ironically the same exact individuals in I think almost every case, often have supported and even proposed legislation prohibiting something called captive audience, which is a similar situation, only it would be the employer talking to their very own employees that they've hired at their own expense on company time when they're paying them. This is a very different situation where we are forcing an employer who has his employees there, presumably on company time that he is paying, and they are being forced to allow an outside entity in to potentially disrupt that working arrangement. Now, again, I have no issue with collective bargaining, and again, I believe that those employees have every right to do so, but things should be fair, Madam President, and I don't believe this is fair when the state law is interrupting what should be a free process where everyone gets to make their own choice by putting its weight on the scale and saying, no, we're going to force the employer to go ahead and provide access to this exclusive representative. It also says that it shall give the exclusive representative no less than 10 days notice. Through you, Madam President, I'm curious where that time frame came from. Is it related to anything else in our laws or requirements regarding how soon someone must join a union when they are first hired? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. Through you, this bill does not require union membership. It doesn't have any dates related to the requirement of union membership. It simply says that having access to an orientation, it's really only truly access if the organization that's being given the access has some notice of when the meeting is going to take place, and 10 days is I think, a good amount of time to make sure that there's someone available to attend that employee orientation. So there's nothing more to it than making sure that when we grant access, that we're making it real access by giving the organization enough time to arrange their schedule to be present.
Thank you, Senator. Senator Sampson.
Thank you, Madam President. So I guess I'm just wondering out loud why it is the public employer's concern about whether or not they should provide access at all, and why they are responsible on top of that to not only provide the access, but also provide a certain amount of notification within a certain period of time. Is there any penalty through you, Madam President, if the public employer fails to comply and, say, notifies the exclusive representative of the union 11 days, or excuse me, only 9 days prior to a meeting?
Senator Kushner.
Thank you, Madam President. Through you, the good senator raised the issue of why should it be the employer's concern, and I think this bill isn't attributing concern. It is simply providing access, providing a procedure, an orderly procedure for employees who are new to the employer to gain information about the collective bargaining agreement that they will be working within, and also to familiarize themselves with the organization that will be there to represent them. And so I don't think there's a question of concern at all. It's just a good procedure to make sure it gets done. The good senator asked if there would be any penalty if they were not to adhere to the 10 days. And I do want to point out that the bill does provide that that there is a provision there that says not less than 10 days, except a shorter notice may be provided in any instance where there's an urgent need to the public employer's operations that prevents the 10 days notice. And I think if there were no urgent need, and if it were fewer than 10 days, then in fact there would be a procedure under this bill to go to the state labor board and ask for file a prohibited practice charge so that could be adjudicated. But clearly, I think the provisions here are pretty written in a way that gives the employer a great deal of flexibility in terms of the scheduling, in terms of if they need for some reason to have fewer than 10 days. And I do want to point out that it is not required by this statute, by this proposed bill, that they actually hold an orientation. Later in the bill, it provides that there's no requirement here that they actually hold that orientation. So there's a lot of flexibility afforded to the employer.
Senator Sampson.
Thank you, Madam President. And I appreciate the chairwoman's characterization of this section. I noticed the language that she chose to use very much sounds like freedom, providing access, flexibility, because those are actually good terms that people want to see in any type of arrangement, especially an employment arrangement. But I don't think that those are accurate terms to describe this section. There is no flexibility whatsoever, and there's no access. It is all about the employer shall provide. They don't have a choice, Madam President. They have no choice. We will be making a law here that says that they must do something. And I believe it was quite clear that this is not about freedom, but as I said, it is about force. And the force is that if you fail to provide for this notification of 10 days, there would be a complaint made to the state labor board, and there would potentially be a penalty and recourse because of it. Do not mistake any of this language for freedom or choice for a municipal employer or an employee. None of that exists in this bill. The only beneficiary of this policy is the union and their representative. That is it, because they are writing and dictating the terms in every way, shape, and form. And I will go back to my statement, which is, as long as it is fair and people are given the choice to make their own decisions, I'm in full support. This bill is once again in this chamber another choice, another freedom of choice taken away from our constituents. Moving on later in the same section, which has to do again with people not even part of the union. These are new employees. On line 40, it says, when negotiating access regarding a new employee orientation, I don't want to read the whole section, but this is what this subsection 3 is about regarding access to a new employee orientation. It says that factors must be considered on line 46 and 47. And I don't understand this because it says in subsection A, one thing that shall be considered is the ability of the exclusive representative to communicate with the public employees it represents. I don't understand what that has to do with a new employee orientation or why that exists in this section, because the section is about new employee orientation. So I don't think that the arbitrator should be considering something that has nothing to do with that. But I'll just move on. I thought that was something that was put into this section erroneously and is very confusing, because I think it creates a situation where we're clouding the issue between someone who is already a member of the union and someone who has not yet made that decision. Moving on to subsection C, which is on line 63. This is access that must be provided to the union representative to already represented employees. So we've moved on from new employees onto people that have already joined the union. But what I think is interesting about this is just the extent of access that this would be provided, here. Before I get into the actual language here, I just want to make a very, very important point, which is that the proponent of this bill, who I have great respect for, the chairman of the Labor Committee, said in her opening comments about this bill is that we do this already. These things are common. We've been doing this for years. And I completely agree with her. We have been doing these things for years. These things are common. The difference is noteworthy and very important. The difference is these things, this access to orientations, this access for the union representative to existing employees and so on, all of these things have been going on because they have been collectively bargained for. And they were collectively bargained for in a relatively free environment. And we're changing that. If this bill passes, Madam President, we will no longer have collective bargaining agreements in the same way that we do now, because unions will no longer have to negotiate for these items. These items happen today. This access happens today because there is a negotiation that takes place. As I said, I don't want to use the term completely free because that's a whole separate conversation, but relatively free compared to making a law like this one that takes away the choice of the parties to be engaged in that decision making. This simply requires it. Period. That's the law now. Section C, a public employer shall provide the exclusive representative access to the public employees that such exclusive representative represents. And it says that access includes, but shall not be limited to, meeting with individuals on the premises. So the union representative is able to go to the premises of the employer during the workday, during paid or unpaid breaks, and also the right to meet, again, with newly hired employees. And all of it without any cost or expense to the union representative, or the employee, but at the employer's expense. And because we're talking about the state or municipal employers, that means the taxpayer's expense. Can I ask just a question through you, Madam President? In this section, subsection C, which is line 63 to line 77, does the chairwoman see any distinction between whether or not it is appropriate for the union representative to have access to employees that they represent versus what it says under subsection 3, the right to meet with newly hired employees. Is there a distinction there? And I'd be curious to know where that it comes from. Is that something that you are familiar with as being collectively bargained for in current practice? Maybe some other contract that currently exists through you, Madam President?
Senator Kushner.
Thank you, Madam President, and I thank you for that question to my good senator, ranking member on my committee. I do want to point out that I think that question points out something that may not be understood by my colleagues, which is under the law, a union represents the employees of a that are hired. Even newly hired employees are represented by that union by virtue of being employed within a bargaining unit, whether or not that person, that employee, has chosen to join the union. And so when you referenced the reference to the earlier line 46, the question about why would you need the opportunity to communicate with someone that it represents when we're talking about newly hired employees, you actually, the union already represents those folks from the day that they're hired. And I think that that issue outlined in line 46 was here specifically not in error, but in fact it was referenced here because we want to give guidance to the arbitrator who might be hearing a dispute about access to orientation would know what the parameters and the guidelines are, and that is in other parts of the statute around interest arbitration. The factors that are considered by an arbitrator are typically laid out like that. So I don't think this was an error, but was in fact intentionally put there. In terms of the issue around access to employees outlined in paragraph C, this section of the bill lays out the opportunities that would be required for employees to have the opportunity to meet with representatives of their organization. There are several different opportunities that are laid out. One is if you needed to have a meeting with an individual during the workday to investigate a grievance or complaint that had been made. One is to have worksite meetings, and the other is to meet with newly hired employees. And this is the section that I spoke to earlier, item number 3 there, which says that there would be an opportunity for a new employee to meet with their representative for at least 30 minutes to understand the parameters of that employment relationship as it pertains to the labor organization. And I would suggest that here it makes clear that this 30-minute period could be done during new employee orientations if they were conducted, or if they were not, then the organization would have an opportunity for no less than 30 minutes to explain to the newly hired employee what the terms and conditions of the contract are.
Thank you, Senator Sampson.
Thank you very much, Madam President, and thank you very much for that information, and that is extremely helpful. The only thing I would point out is that it is certainly beneficial to the union itself for participation to be willful, rather than a situation where the union is representing employees that have not willfully chosen to become a part of the union. And that's why I believe this bit of the language exists in this subsections 3 of subsection C, starting on line 71 and ending in line 77. And I'll just remind this body once again that this is very much in direct opposition and complete hypocrisy to the attempts by the majority party throughout my tenure here in the legislature to enact legislation prohibiting employers from doing the exact same thing, which is having a purposeful meeting with newly hired employees for the purpose of trying to sell them on the idea that they should become members of the union. If the employer was doing that, I think that it would be frowned upon by the folks proposing this bill. And that's my objection to it more than anything else, because I believe all parties should have an opportunity, and that employee number one, is the one we should be concerned about more than any other soul as far as protecting their freedom to make choices. Line 78, I read this sentence and I just had to stop and circle a word. It says, in addition to any public employee organization's right to employee information. I'm seeing the word right show up in more and more bills lately, Madam President, and I just want to make it clear for my colleagues what exactly a right is. A right is something that you are born with that does not infringe upon someone else. That's the only thing that can possibly be a right. So when I hear things like the right to health care or the right to access some employee's information, I don't think that can ever be a right. Because if you are forcing someone else to do something, you are in essence violating that person's rights. So I just want to make that clear. They might have access by force, and that's what this line should say. In addition to any public employee organization's access to employee information by the force of law created here, would be a better way to term that sentence so that people understand exactly what is happening, because it is absolutely, most certainly not a right. It says that that right exists, that the employee organization would be able to receive. I'm trying to shorten up what I'm going to say here because I don't want to read the whole section to make it clear. But essentially, all of the pertinent and personal data regarding these employees every 120 calendar days. And this is through lines 81 of 96 of the bill, if you want to take a look. And basically, it just says that every 120 days, the employer, whether they want to or not, by force of this law, would have to provide all of this detailed information to the representative of the union. I've already pointed out in the discussion on the amendment that is in direct conflict with existing law. And in fact, a penalty that exists in our freedom of information laws exists for employers that do just that. And I don't understand why that was not addressed in this language. I believe if this bill was supposed to take precedent over that existing law, then it should have been addressed here. But instead, we are going to end up passing this into law, potentially in direct conflict to another statute, which I don't think benefits the public, and I certainly don't think it benefits even the advocates of this legislation, because what they're doing is they're leaving themselves open to a legal challenge because of the lack of clarity involved. Moving on, I thought this was something pretty substantial. On line 97, we're adding to the list of things that municipal employer must provide, willingly or unwillingly, the right, again, I circled it again because it just stands out to me, to use the electronic mail systems of public employers. So basically, what we're going to do here is we're going to put the weight on the scale so much of the union in this particular legislation that they are going to force the municipal employer to use their own electronic email system to help the union get their membership. This was never the idea behind collective bargaining, particularly for public sector employees. This is weight on the scale like we have never seen before, Madam President, when it comes to how this negotiation is supposed to go down. Just moving on. Section F takes it from providing personal information every 120 days and beyond using the municipality's email system, all the way up to Section F, which is that union representative will have the right again to use state and municipal government buildings that are paid for by taxpayers. And they will be able to use these to conduct meetings with bargaining unit members. There's a section here that says on line 114, without undue interference, and the employer may place reasonable restrictions. Oh, I'm sorry. The representative of the union can make hold these meetings without undue interference and may place reasonable restrictions on the conduct of individuals attending. I just through you, Madam President, can I find out what is a reasonable restriction? Who would be restricted from such a meeting and why? Through you, Madam President.
Senator Kushner.
I think that it would be determined by I think what the bill intends to do here is make it clear that the unions, the employees are going to have an opportunity to meet as a union on the premises where they work or within the municipality, or if they work for the state, in a building, in a room that they have access to, easy access to, perhaps, so they can have a meeting, and in that meeting that they would be in a position, the organization, to ensure that it was an orderly meeting and that it couldn't be disrupted. And if it if someone were to be disruptive, then they would have the opportunity to ask them to leave. I think it's pretty clear.
Senator Sampson.
Thank you, Madam President. Well, just as a question, it says that an exclusive representative shall have the right to conduct such meetings without undue interference and may place reasonable restrictions. Does that mean that the employer or a representative of the employer would or would not be allowed to attend such a meeting and to speak in favor or in opposition of the benefits that the union offers to employees of the municipality or the state? Through you, Madam President.
Senator Kushner.
Yes, I think it's through you. Thank you, Madam President, and through you. I do want to say that I think this is intended to make sure that the employees have an opportunity to meet amongst themselves without the undue interference of their employer. And I think that would be an appropriate interpretation, that they could have a meeting and feel free to say and comment anything they wanted to during that meeting without this surveillance or participation by their employer.
Senator Sampson.
Thank you, Madam President. I appreciate that answer, especially since how it is in such unbelievable conflict from what we heard early in this debate, that the union is affiliated with the employer. It doesn't sound like much of an affiliation when the employer must provide the space at their expense, the taxpayer's expense, and they are unable to participate in that discussion. Again, these are perfectly acceptable things if they are negotiated for freely. For us to put this in statute, I believe, is a bold and brazen way of affecting the outcome that I think is in direct conflict with the idea of a free society, particularly in a case where we are talking about the expense falling on the taxpayers that we all represent. Moving on, starting in section 1 or section I, which is another subsection of section 1, on line 126, this is where we start to get into the agency fees. It says a public employer shall honor employee authorizations in any form that satisfies the requirements of sections 1-266 to 1-286. Just a simple question through you, Madam President, and I expect the proponent, the good chairwoman, to suggest that it does in fact, but I will ask anyway whether this section complies with the Supreme Court decision, Janus versus AFSCME. Through you, Madam President.
Senator Kushner.
Thank you, Madam President. Through you, I don't have that statute in front of me, but I'm sure it can be looked up and we can make certain that it does comply with the Supreme Court. But it is my assumption, based on what this bill is seeking to do, that it would be in compliance with not just the Supreme Court, but any statutes that we have here in Connecticut.
Senator Sampson.
Thank you, Madam President. I kind of expected the answer, but I thought it was worthwhile to ask the question simply because I think that is really, in many respects, a major part of this bill. And what is in question here is the Janus decision, its impact on public sector unions across the country, and how this legislation, I believe, is designed to be a workaround more than anything else for that. It goes on to say in line 136, public employers that provide for the administration of payroll deductions should rely on a certification from any public employee organization requesting that deduction. Why not, through you, Madam President, would the municipal employer not rely on the employee themselves to tell them what deductions should come out of their paycheck? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. I think this section makes clear that there has to be a written authorization agreement between the union and the employee to have dues deducted from their payroll, from their paycheck. And I think the reason that this is it's important to adhere to the law. Even before Janus, there had to be, let me restate that. Because of Janus, clearly there has to be a written authorization to deduct dues. And so what this does is create that opportunity for the union to gain those written authorizations and then to inform the employer that they have those. So I don't think there's anything particularly complicated about this. I do think that it's important to recognize that the relationship of an employee to their representative, it's a relationship that they should have control over, that they should be involved in, and not the employer. And I think in this case, the union provides the employer with a list of employees that have signed such authorizations, and that actual contract between the employee and their organization is not something that the employer would necessarily need to see.
Senator Sampson.
Thank you, Madam President. And I'm not surprised you would say that, Madam Chairwoman, but I completely disagree. I mean, you basically just said that this is between the union and the employee, but the employer doesn't matter. The employer's the one paying the bill. And I will just remind everyone that in this particular bill, the employer is us. The employer is us. The employer is us. Everyone in this room, everyone listening who pays taxes in the state of Connecticut is the employer. We're paying for this. If this affects a municipal union agreement, then it affects your property taxes. We are the employer, and I believe the employer does have a say, and the employer does matter. And I believe that in this relationship, the employer and the employee will matter more than any other participants, because ultimately that is what's happening, is an exchange of work for pay between those parties. The union facilitates that arrangement. It may benefit greatly the employees, and I believe that they should have the choice to do so. But what this bill does, again, is put weight on the scale for things that have been collectively bargained for before by putting it in the law where it does not belong. And not only does it put things like this in the law, it does it in such an heavy-handed and unfair way. And here's an example. Moving down to Section K. A public employee organization or public employer shall only be liable for the amounts improperly deducted. No further damages or penalties shall be awarded by any public agency or court. Why does that limitation exist? What if it was done maliciously? What if there is no significant penalty? What it discourages that activity? Because if you look further down in the section, you see on line 165, a public sector or a public employer shall be liable to a public employee organization without recourse to the employees for the full amount of dues et cetera, et cetera, et cetera. I don't want to read the whole section to you. The failure of an employer to comply with the provisions of this section shall be a violation of the duty to bargain and an unfair labor practice. These are two completely different standards. On one case, you can make a mistake and it's okay. You only have to fix the mistake. On the other hand, if you make a mistake, you are subject to being penalized and guilty of violating the duty to bargain and committing unfair labor practices. It's just a repeated theme in this bill that it is completely one-sided and only for the benefit of one of the three parties. Three parties are involved in every aspect of this bill. The municipal employer or the state employer, which is the taxpayers in every case that we pay for, the employee themselves, and the union itself and their representative. And in every situation, in every section, the only one who benefits is the union representative, which is why I started my entire conversation by reminding everyone listening that this is not about helping the employees at all. Employees should have the choice to join unions all day long. I believe in that as much as anyone of any party anywhere. But what they shouldn't have is the right to interfere with this relationship in this way without collectively bargaining for it. I think that's enough about the bill, but I want to just refer to some existing contracts because I want to make a point about the contracts that currently exist. The good senator mentioned early on, and we touched on it a couple of times, which is that these things are happening already. I have the contract between AFSCME and the Administrative Clerical Bargaining Unit. Just as an example, I mean, I could have pulled anyone at all. But if you look at this contract under Article S, Union Rights, Section 4, it says state telephones and or email may be used by a steward or an employee to contact the union for labor management exchanges. So you're right. This is already happening. But there is a big difference from it being negotiated voluntarily by the parties versus us putting it in the law and taking that freedom away and replacing it with the force of law. Section 5, they shall be permitted to enter the facilities of such agency at any reasonable time for the purpose of transacting union business. Again, no problem with this, Madam President. It's in the contract that was negotiated for voluntarily and signed by the parties. I could go on and on. Union access to public information and materials. New employee orientation in Section 10. Once a month at each agency or facility, all new employees shall be released from work if they so desire for 1 hour without loss of pay to attend a union orientation. That leads me to an important question, Madam President, because I did not see in the bill, which will become law, the language, if they so desire. So through you, Madam President, does the employee have a choice whether or not this access will be provided to the union representative if this bill passes? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. I believe this, through you, this is very clear that under this bill, if it becomes statute, an employer will be required to provide access to the union representative, the representative of the employees, to orientation meetings.
Senator Sampson.
Thank you, Madam President, but that was not my question. My question was, does the employee have an obligation to be part of this access that is forced to be provided, or can they choose not to attend? Through you, Madam President.
Senator Kushner.
Through you, Madam President, I think the bill speaks only to the employer the requirement on the employer to allow access to the new employee orientation.
Senator Sampson.
Well, thank you, Madam President. For legislative intent, then, since it's not in the bill, would an employee be required to participate in such an orientation where the exclusive representative of the union is there to It doesn't really say what they're there for in the bill. Forgive me. I think we know what they're there for, but it doesn't say. But when they have access, would the employee be required to be present? Through you, Madam President.
Senator Kushner.
Thank you, Madam President. Through you, I believe that it would be understood that the employees, when they are when they are invited by the employer to attend a new employee orientation, I think the expectation would be that they would have to attend.
Senator Sampson.
Yeah, thank you, Madam President. Yeah, I think that's a very important distinction, that we are essentially creating a law that now says that new employees to municipalities and the state going forward will have essentially no option other than to listen to the union representatives' pitch. Something that did not exist before, as far as I know, and was only there as a courtesy based on the contract that we just looked at. I've got another contract here. This is one between the Corrections Bargaining Unit and Council 4 of AFSCME. And this one, I'm going to come back to that section in a second. Under Article 7, Union Rights, again, this one, Section 4, access to premises, the AFSCME representatives and staff shall be permitted to enter the facilities at any reasonable time. Section 5, the department will continue to permit use of certain facilities for union meetings. Section 6, mailings and handouts. The employer will permit the union to leave handouts in specified areas to allow the union to use mailboxes where available. Again, all these things are fine because they were negotiated for. Under Article 8, training. This is the orientation piece here. Again, on that contract, new employees may be required to attend orientation training on a live-in basis. During such training, they will be required to attend sessions on the schedule established, for which they shall receive the normal bi-weekly salary appropriate to their job. Their duty station shall be considered the training site for the duration of the program. I don't believe that it is required that they communicate with the union representative, though. The point of all of this conversation is the difference between something that is happening based on freedom and the voluntary acts of the parties involved, or by the force of this legislature. Since we've been talking about it, I want to bring up the Janus decision very quickly and delve just a little bit into how it interacts with the bill before us. A Supreme Court decision is not something that you can really summarize in a few sentences, but it is a relatively short decision, and I would encourage anyone interested to read through it, because I think the overall context of this decision is to make it extremely clear that the employee is the one whose rights needs to be protected above all else, and that their decision-making is their own. And that applies not only to the access that an employer or a representative of a union might have to them, but whether they participate in that union, and finally, whether or not money comes out of their pocket. All of that, according to this Supreme Court decision, is very clear that it should be left up to the employee. In the syllabus, the Supreme Court held number 2, the state's extraction of agencies from non-consenting public sector employees violates the First Amendment. The First Amendment, of course, we all know is the amendment that has to do with free speech. And they are essentially suggesting here that the spending of those dollars is, in effect, them using their ability to speak, to make their personal decision known about whether they want to participate. I think that's very interesting. There have been other Supreme Court decisions that have often held the same thing. Citizens United, which many people listening might be familiar with, also held the same exact concept, which is that someone spending money is essentially doing so in place of their speech. The final paragraph of the decision says, for these reasons, states and public sector unions may no longer extract agency fees from non-consenting employees. The term non-consenting means so much, because that's what the problem I have with the bill before us is, Madam President, is that it's all about non-consenting. If people were consenting to things, it's a much different discussion. That's the point of the bargaining agreements. These are consenting agreements, as opposed to a non-consenting agreement created by this body in the form of a law. The First Amendment is violated when money is taken from non-consenting employees for public sector unions. Employees must choose to support the union before anything is taken from them. Accordingly, neither an agency fee nor any other form of payment to a public sector union may be deducted from an employee, nor may any other attempt be made to collect such a payment unless the employee affirmatively consents to pay. Now, I understand that this decision has to do with agency fees in particular, but I do believe that this same court, given the opportunity to discuss whether or not someone's private information could be given up without their consent, would come to the same exact conclusion as I have, Madam President, which is that the union has no right to that information without the consent of the employee, and we have no right as the representatives of our constituents to say that someone else can force some other third party to give up that information. And as a result, Madam President, I have a few amendments to address those concerns, because I do believe that we can improve upon this bill if we cannot, in fact, make it something that is acceptable. We have to at least try to solve as many problems as we can. The first one is LCO 8405. I believe the clerk is in possession of that amendment. I ask that I be allowed to summarize the amendment, and we'll start there, and we'll go after that. Maybe we'll have an opportunity to vote on it.
Mr. Clerk, please call the amendment.
LCO number 8405, Senate Schedule B.
Senator Sampson.
Thank you, Madam President. This is a very straightforward amendment. It's very difficult to read because it references several different line numbers, but I assure those listening that this amendment, the meat of it, is on lines 4 through 8, which basically says that in line 11 of the bill, it says, insert, a public employer shall not disclose any information to an exclusive representative pursuant to this section concerning any newly hired employee who has provided written notice to the public employee requesting that such employee's information not be disclosed. Essentially what it does is it gives the employee an opt-out of whether their information is provided to the union representative by the employer. This amendment is here to make it completely and abundantly clear that I believe, and people who will vote yes believe, that the employee does have the ultimate say, that it is their choice whether this information is provided or not. If you believe the employee is the one that should decide whether the information is given up or not, you vote yes on this amendment. If you believe that this body has the right to dictate that for a free person, then you can vote no. I urge adoption, Madam President. I would like to make a motion that we accept this amendment, and I'd like a roll call vote. Thank you.
And the question is on adoption. A roll call vote will be held on the amendment that is before the chamber. Will you remark further on the amendment that is before the chamber? Senator Kushner.
Thank you, Madam President. A lot of what's been said here today is hard for me to listen to because it's a world that I know so well and spent so much time devoted to developing employee organizations and promoting employee rights and fighting to ensure the dignity of workers and having a voice at work. And so clearly this bill is something that's very important to me and to the people I represent. And I do want to say that this amendment, I think, would really would take away from what we're trying to accomplish here, which is making sure that every worker that is newly hired into a public employer in this state has an opportunity to understand what are the parameters of the collective bargaining agreement, and that this would then would really undermine the intent of this bill. So I recognize the good senator, and I have a very different view of this, and I appreciate your kind words earlier. I also believe we've had a good working relationship, but on this we really disagree. So I would urge my colleagues to vote no on this amendment.
Thank you, Senator Kushner. Will you remark further on the amendment that is before the chamber? Senator Martin.
Thank you, Madam President. I see this side of the room works today. Thank you to the technicians who did the work. I rise to support this amendment. I just began reading this piece of legislation. I have family members who are part of a local union, and just very quickly, this just reeks of someone taking an organization speaking on someone for someone else before they even have had the choice of making their own decision on whether or not they want to share information on who they are, where they live, place of where they work or the building where they work, a phone number. Some of that's pretty private stuff. And I know some of you here in the circle are maybe private with your own information because of the elected position that we all have. So this piece of legislation is given this pre-authority or pre-authorization to make a decision on someone else's behalf before they even have that choice. I don't agree with that. That is really an intrusion of individual rights. So I'm standing here. I'm going to continue listening and reading, but for now, I agree with Senator Sampson with this amendment, and I urge my colleagues to approve or adopt this amendment. Thank you.
Thank you, Senator Martin. Will you remark further on the amendment that is before the chamber? Will you remark further on the amendment before the chamber? Senator Kushner.
Thank you, Madam President. I just do want to make clear for the record that in most cases, the information that is being provided here is FOIable when workers work for the state, when they take on that job, with a few exceptions that are good exceptions to protect the safety of certain employees of the state who might, to protect them against criminal acts like our police officers. Other than that, this information is FOIable. Thank you, Madam President.
Thank you. A roll call vote has been requested. Will you remark further on the amendment before the chamber? Will you remark further? If not, I will open the vote. Mr. Clerk, please announce the roll call.
Immediate roll call vote has been ordered in the Senate. Immediate roll call vote in the Senate. LCO number 8405, Senate Schedule B. Immediate roll call vote has been ordered in the Senate. LCO number 8405, Senate Schedule B. Immediate roll call vote in the Senate. LCO number 8405. Immediate roll call.
Have all the senators voted? The machine will be locked. Mr. Clerk, please announce the tally.
Senate Bill 908, LCO number 8405. That's Senate Schedule B. Total number voting 35. Total voting yea 12. Total voting nay 23. Absent not voting 1.
And the amendment fails. Will you remark further on the bill before the chamber? Senator Sampson. I think we need to get your microphone on, sir. There we are.
Thank you very much, Madam President. So I'm disappointed that the previous amendment failed because I think it was a very simple question. It's really boils down to whether or not we believe the decision maker about their participation in a union representation agreement or even giving up private information, including someone's home address or their email, should be up to that employee or to this legislative body in the form of this law, which will compel a municipal or state employer to provide it. I think it's a simple question, and I think that it's very telling. I appreciate the chairman of the Labor Committee and her words. I believe she believes them truly, that she is helping employees. I think this has to do with our worldview. My worldview is that the ultimate moral power that we have is freedom. That every person should be able to enter into every agreement that they do in life willingly and freely. And this bill does not do that. This bill says that that employee must give up their private information, whether they want to or not. It even says that they have to attend an orientation where they may be encouraged to join the union, whether they want to or not. And all of this happening without their freedom of choice. I don't see how anyone could say that they are looking out for the employee in that case. I just don't understand that. And I'm afraid and very disheartened by the idea that some will characterize this debate, and particularly my words and comments here, as being anti-union or somehow opposed to collective bargaining. I could not have been more clear throughout this debate that I believe that every person has the right to make that decision for themselves. And in the case where unions provide a benefit, they should be making that case to the employees so that the employees can decide whether or not that is a benefit and they want to do that for themselves. I also believe that is the whole point of the Janus Supreme Court decision. This bill undermines that in every conceivable way. Madam President, I have another amendment. It's in a similar vein. The First Amendment allowed an employee to opt out of having their information provided if they so chose. This is a similar amendment that requires affirmative consent by an employee prior to their personal info being given to the unions. It's a similar concept, but the idea here is similar, that it's up to the employee whether or not that information is provided. Again, 3 different entities we are referring to. You have the employer, which could be the state or town, you have the employee themselves, and then you have the union. I believe all 3 of those entities should be on the same level playing field, and they should all have equal opportunity to do what they need to do, but every person and every entity should be able to make their own choice of their own free will, and that no one and no entity should be forced. And in this case, this bill forces not only the employer, the state or municipal employee, to do things that they may or may not agree with, and I also pointed out that they might even end up being penalized because of conflicting statutes for doing so, but it forces employees to do things that they don't want to do also. Those things are wrong, Madam President. This amendment basically reads that each public employer shall provide notice to and obtain written informed consent from an employee each time such public employer seeks to release employee information to a public employee organization. I don't know how you vote against this, Madam President. I really don't. It is extremely simple in concept. Before my information is given away, I have to consent to that. How hard is that? I urge my colleagues to support this amendment. Let's make this bill, which is decidedly unfair currently, into something that resembles fairness and freedom of choice for employees. I urge adoption, and I'd like a roll call vote. Thank you, Madam President.
And excuse me, Senator Sampson, we do need an LCO number to
I
proceed with
apologize that I did not give the clerk the LCO number, and it is 8413. And as I said, I urge adoption and would like a roll call. Thank you.
Thank you, and we will have a roll call vote. Mr. Clerk.
LCL number 8413, Senate Schedule C.
And the question is on adoption of the amendment that is before the chamber. Will you remark further on the amendment before the chamber? Senator Kushner. Senator Kushner chooses not to remark. Senator Champagne, I do apologize if you were wanting to speak. Senator Champagne.
That's okay. Thank you, Madam President. I actually stayed seated because I saw Senator Kushner standing up and was going to give her a chance. I want to make a point. Senator Sampson bringing this forward makes perfect sense. When I go to the doctor, they give me a privacy notice once a year. They tell me what they're going to do with my information. Once a year, I get something from the credit card company. They tell me what they're going to do with my information. Every year, I get something from the bank. They tell me what they're going to do with my information. I expect my employer to tell me what you're going to do with my information. And if you're selling my information or you're giving it to somebody and I didn't give you permission, and that information gets used for something that I didn't want it to get used for, I'm going to have a serious problem with that. If all of a sudden I'm at home and I receive a phone call from somebody who ended up with my private unlisted telephone number and they say, well, I got it from your employer, I'm going to have a problem with that. I should be able to say no to my employer. Do not give my information to anybody. Do not give my information to politicians. I don't want them calling. Don't give it to anybody unless I give permission. So I rise in support of this amendment, and anybody that votes no to this, I see as saying that your private information is for sale by your employer. Thank you, Madam President.
Thank you, Senator Champagne. Will you remark further on the amendment before the chamber? Senator Kushner.
Thank you, Madam President. As has been said before, I do want to remind my colleagues that the information that we're speaking of is foiable, that when a person is hired by the state, they understand that their information can be obtained by the public, and often is, and we're all familiar with that, having been elected and been through FOIA requests ourselves. And so this information is foiable, and I do want to remind my good colleagues of that, and I would urge a no vote on this amendment.
Thank you, Senator Kushner. Will you remark further on the amendment before the chamber? Senator Witkos.
Thank you, Madam President. If I may, a question or two to the proponent of the amendment.
Yes, please proceed. Senator Kushner, prepare yourself. Oh, I do apologize. We've had a flurry of amendments. So, Senator Sampson, prepare yourself.
Thank you, Madam President. Senator Sampson, I'm just going to, if I know you were in a private conversation a minute ago, but I just want to, hopefully I'm paraphrasing it correctly to the previous speaker who just made a comment that if you are hired by the state of Connecticut, then your personal information is already foiable as a provision of the contract or your acceptance of employment. Hopefully I said that correct. looking for a sign from Senator Kushner. So I guess without acknowledgement of what my summary of what she just said, that's what she said. And I'm asking to you, Senator Sampson, through the chair, is that I'm understanding that in some professions in our state that the personal information is not foiable. We have created carve-outs and exceptions. And is that correct through you, Madam President?
Senator Sampson.
Thank you, Madam President, and thank you, Senator, for that question. It's a very important one. I do not believe that all of the information that is contained in the language of the bill is foiable, and certainly not for every employee. Some of these items may, in fact, be able to be obtained by FOIA, but as was mentioned, there are certain state employees that have specific protections, and many of those protections happen, as we have discussed throughout today's debate, inside a negotiated voluntary agreement, which is a collective bargaining agreement, where those protections exist. So I guess that's a two-part answer to the question, which is I believe some of this information is foiable. In some cases, not all of it certainly, and there are some employees that would certainly not be able to have their information found in a FOIA search. Thank you, Madam President.
Senator Whitkos.
Thank you, Madam President. And I thank the proponent of the amendment for that answer. And that just confirms and solidifies to me why we should be supporting this amendment, because we've heard from the proponent of the underlying bill that this information is readily available on all employees, when that is not accurate, Madam President. If I had the time, I would go through our state statutes and I would pull out the exceptions to the FOIA laws that pertain to individuals that are employed in this state of Connecticut, that this body created, from judges to police officers to, I'm trying to think off the top of my head, there's some certain healthcare workers. Maybe if I'll throw it back to the question form to Senator Sampson, if he may elaborate, if he knows off the top of his head, what are some of the other employee classifications in our state that their information is not foible? Through you, Madam President.
And I'm going to take that as a question. Senator Sampson.
Thank you, Madam President, and I appreciate the question very much. I don't know that I want to attempt to try and list every particular type of state or municipal employee that might not be subject to FOIA in this way, but certainly it's extensive in the way that the good senator just mentioned. You have people that work in law enforcement, people that work in healthcare. I would also add to that many state employees are protected via the supersedence clause that exists in our laws that allow state employee collective bargaining agreements to go around the existing law and, in many cases, protect that information. I presume that those supersedence laws would still take precedent, and even if this law were to pass, would override the requirement in this bill. Through you, Madam President.
Senator Whitkos.
Thank you, Madam President. I thank the gentleman for that answer. I believe that this amendment that is before us is well placed. It takes into consideration those individuals who may not want their information shared with anybody. They may be a victim of a domestic violence situation, or may have restraining orders against certain individuals, that information is so private to them, they just don't want that information given out there. They've gone on every do not call list. They don't have anything published. And we are passing a law that says the employer must give it up. And that's just not right. Give the employee the choice. And we often talk about choice in this circle, Madam President, and this is one of those instances where the employee should have the choice on whether or not their information is divulged or not. And I urge adoption of the amendment. Thank you, Madam President.
Thank you. Will you remark further on the amendment? Senator Kushner.
Thank you, Madam President. Through you, I do want to just make it clear that in an earlier comment that I made, I was clear that there were some employees that were not, their home address was not foiable. Particularly, I mentioned police, so I am aware of that, and just wanted to make sure that we're in agreement on that.
Thank you. Will you remark further on the amendment? Senator Champagne.
Thank you, Madam President. I know it is my second time Thank you for indulging. I just have a question for Senator Kushner.
Senator Kushner, prepare yourself. Go ahead, sir.
Thank you. Through you, Madam President. Something that Senator Wicko said, how do you distinguish between those that have protective orders or restraining orders in protecting their information if this law is sent forward?
Senator Kushner.
Thank you, Madam President. Through you, this bill does not address that.
Senator Champagne.
Thank you, Madam President. So that tells me that they aren't protected, and this information would be released by law, and then somebody somewhere is going to be held financially accountable. Thank you.
Thank you, Senator. Will you remark further on the amendment before the chamber? Will you remark further on the amendment? If not, a roll call vote has been requested. Mr. Clerk, kindly call the roll call vote, please.
Immediate roll call vote has been ordered in the Senate. On Senate Amendment C, LCO number 8413. Immediate roll call vote has been ordered in the Senate. Senate Amendment C, LCO number 8413. Immediate roll call vote in the Senate. On Senate Amendment C, LCO number 8413. Immediate roll.
Please announce the tally.
Senate Bill 908, Senate Amendment C, LCO number 8413. Total number voting 35, total voting yea 12, total voting nay 23, absent not voting 1.
And the amendment fails. Will you remark further on the bill? Senator Sampson.
Thank you, Madam President. Again, another amendment unfortunately defeated, an amendment that simply would have required that informed consent be obtained from employees before their information was to be given out. I'm somewhat shocked, Madam President, that amendment failed in this chamber. I thought that we would at least find agreement that someone's private information was indeed their decision to give out and not a third party or this body by the force of law. Just following up also, early on in our discussion, we talked about the conflict that this legislation, if it becomes law, would have with existing statutes. And I pointed out some labor law and also the existing FOIA statute. And it occurred to me, unfortunately, after I spoke on the amendment, the number of folks that actually are protected in the FOIA statute from having their residential address disclosed. And it is a substantial list. And my expectation from this legislation is that despite their protections that exist in Section 1-217, these folks, federal judges, sworn members of municipal and state police departments, employees of the Department of Correction, firefighters, inspectors at the Department of Criminal Justice, employees of DCF, members of the Board of Pardons and Paroles, and so on. I could just go through the list. Those folks are going to end up giving up their information via the language in this bill, and coincidentally create a problem in Section E of that same statute, which could leave them in harm's way and responsible for willfully and knowingly violating provisions of that section of our law. I'm disappointed that in the process of developing this legislation that someone had not thought it through, that needed to be addressed. Because I believe if we leave here and this bill becomes law in its current form, there is going to be conflict, and you're going to end up having municipal governments in particular trying to figure out exactly how to accommodate this law without being in violation of other existing statutes. We talked about how there's 3 parties involved in this legislation. And I want to just bring it home on the subject. We talked about employees and their rights as being paramount. And I did my best to try and change this bill in a way that would protect employees' rights by providing them an opt-out or at least informed consent. With the failure of those amendments, I want to just move on to trying to protect municipal employers. And by virtue of protecting municipal employers, This also would protect the state as well, but I'm more concerned about the impact on towns because I believe the state is equipped in many respects to handle this situation, and individual municipalities may not be. When I say affecting a municipal employer, people listening should recognize I'm also talking about them as taxpayers in their communities. Because anything that impacts a municipality is obviously going to impact the people that are paying taxes in that town. So with that, Madam President, I have an amendment. This one, and I will give you the LCO in advance. I apologize for before. I was on a roll. Is LCO 8393. And this amendment, very straightforward, strikes certain sections of the bill. And simply what it does is it would eliminate and prohibit the use of state and municipal property by the exclusive representative as a matter of law in the bill. That doesn't mean it could not be collectively bargained for as it has been, or it could not be offered simply as a matter of course. But what it would do is remove it from this bill and therefore becoming law. I move adoption and like a roll call vote. Thank you, Madam President.
Thank you. And when we do take a vote, it will be by roll. Mr. Clerk, please announce the LCO amendment.
LCO number 8393, Senate Schedule D.
And the question is on adoption of the amendment that is before the chamber. Will you remark on the amendment before the chamber? Senator Champagne.
Thank you, Madam President. And I'm going to speak on this as well. I have two jobs. In my other job, I run a municipality, and we have public buildings. The state doesn't come in and tell me what I have to do in my buildings. I rent this building out to our buildings out to people, and we require them to provide proof of insurance. In order to use our buildings, we want proof of insurance. It's not a hard thing to ask for. But here we are, the state's coming in and telling a municipality, you're going to let somebody use your building, and it sounds like without any compensation. So they're telling the taxpayers of the town, you're going to provide electricity, heat, hot water, bathrooms, everything else necessary in that building without compensation, without a bargaining agreement. If that was in the bargaining agreement, and it was bargained between the union and the town, that's one thing, that because we came to an agreement. This is state lawmakers coming in and saying, this is what you're going to do. You're going to do it. We don't care what you say. I don't believe that's right. And while we're talking about this, there was another part of this when something was brought up about these meetings being held in our public buildings. The proponent of this bill said that, well, if somebody's disruptive, they can have them leave. Can have them leave. How do you force somebody out of a building you don't own? How can you tell them to leave? You don't own that building. All of a sudden a fight takes place, somebody gets hurt. Who's responsible? Who's liable? Been a union member for 22 years. And during that time, we've had disagreements in our meetings. We've even been in meetings where chairs have been thrown. I support these meetings, but I also want to make sure that the town's not liable because the state stepped in and said, do as I say without question. It's like the town saying, we want to use this room, and you don't have a choice. There's many problems with this bill, and I'm starting, and I see a theme going on here, and I'll close when I talk about the main bill and start talking about that. But I urge people to support this. No, the state should not be telling your towns what to do in their buildings. Plain and simple. Thank you, Madam President.
Thank you very much, Senator Champagne. Are there any further comments? Senator Kushner.
Thank you, Madam president for the moment, I believe. I don't know if that's the best way to say that because I haven't ever addressed you there before, but thank you for the opportunity to speak. I just want to point out that I think this bill without amendment such as this is a good bill, and that the amendment would not improve the bill, would in fact really undermine the bill and what our intent is here today. So I would urge my colleagues to vote no on the amendment.
Thank you very much. Senator Kushner, will you remark further? Will you remark further? Seeing no further remarks, we will have a roll call vote on the amendment. Mr. Clerk?
Immediate roll call vote has been ordered in the Senate. Senate Amendment D, LCO number 8393. Immediate roll call vote in the Senate on Senate Amendment D, LCO number 8393. Immediate roll call vote has been ordered in the Senate on Senate Amendment D, LCO 8393. Close out. All right. Senate Bill 903, LCO number 8393, Senate Amendment D. Total number voting 35, total number voting yea 12, total voting nay 23, absent not voting 1.
Thank you very much. Amendment fails. Will you remark further? Will you remark further? Senator Sampson.
Thank you very, very much, Madam President. Good to see you up there this afternoon. So that was the third straight amendment that I've offered that went down on a party line vote, and I find that to be unfortunate. If folks have been watching, they will notice that there is a theme to my amendments, and that theme comes from my opening comments on the bill, which is that this subject is freedom versus force. I have tried to put freedom back into the bill before us in giving the employee the ultimate choice about their private information and not a third party or this body. And the most recent one was to give municipalities freedom of choice on how their property owned by their taxpayers should be used. It's been mentioned that many of these things have been happening for years, that unions do use state and municipal property, that employees do give out their information. All true, but again, all done voluntarily via freedom in a private contract, or rather a contract called a bargaining agreement. This law before us is going to take a significant portion on one side of that agreement and put it into our laws, creating a great disadvantage for the opposing negotiation of the other side. I want to offer another amendment in an effort to illustrate once again that freedom is the proper choice here. Section 1, subsection E of the bill says that the exclusive representative of the union shall have the right, as I pointed out before, which is not a right at all, to use the electronic mail system of public employers to communicate with bargaining unit members and so on. I find that it's very interesting because the final section of the bill, which is in section 2, subsection O, subsection 4, says that it shall be a prohibited practice for a public employer to permit the use of the employer's electronic mail system by any entity to discourage membership in a public employee organization, and so on. So this bill makes it very clear that the union can use the public employers' email system for their purposes while simultaneously prohibiting any opposing viewpoint. That's not the way things should be done in a free society, Madam President. In a free society, people should be able to make their own choices. And this bill, as I've mentioned several times, is the exact opposite of that. So the clerk is in possession of an amendment. This one is LCO number 8496. And this is a very simple amendment that would strike the very first section that I mentioned, which was section...
Senator Sampson, can we just go through the process first? We're calling the amendment, so let Mr. Clerk announce it, then you can do your discussion.
I would be glad to, Madam President. Thank you.
Thank you. Mr. Clerk?
LCO number 8496, Senate Schedule E.
Thank you very much, Mr. Clerk. And this is on adoption, sir?
I move adoption.
Thank you very much, sir. Please continue.
Thank you, Madam President. Forgive me, I'm on a roll and I'm getting ahead of myself sometimes, and everyone has their own way of doing these protocols. I like to turn my summary into my argument for the amendment, which I've already made. Very simply, this would eliminate the requirement that public employers but must by force provide the use of their electronic email systems. And as I said, I move adoption, and I would like a roll call vote, Madam President. Thank you.
Thank you very much, Senator. Will you remark, Father? Will you remark, Father? Senator Champagne.
Thank you, Madam President. Allowing employees or the representative of the unions access to our email systems. Many towns have been attacked. Their systems have been hacked and have paid hundreds of thousands and even millions of dollars. And now this law is going to give them access to our email system. I'm going to say that's wrong. I'm going to talk more about this later, but I'm going to say this is wrong. You know, we spend every single year hundreds and hundreds of thousands of dollars to protect our email system. Everything goes through the cloud. You know, that's a system we put in place, we paid a lot of money for. And now we're talking about giving access to an outside person to our system. I hope I'm reading this wrong. I hope I'm understanding this wrong. I'm going to ask for more clarification later. But they should not have access. They should have access to the private emails, and they can go through it that way. They should not have access to our public, taxpayer-funded, very well-funded email system that we do everything we can to protect. Thank you, Madam President.
Thank you very much, Senator Champagne. Will you remark further? Will you remark further? Senator Kushner.
Thank you, Madam President. And I would just urge my colleagues to vote no on this amendment. I think we have a good bill without this amendment, and I would urge a no vote on the amendment. Thank you.
Thank you very much. Will you remark further? Will you remark further? Seeing no further remarks, Mr. Clerk, if you could call for a roll call vote on Senate Amendment E, I believe.
That's correct. Immediate roll call vote has been ordered in the Senate. Immediate roll call vote has been ordered in the Senate. Senate Bill 908, Senate Amendment E, LCO number 8496. Total number voting 35. Total number voting yea 12. Total voting nay 23. Absent not voting 1.
The amendment fails. Will you remark further? Senator Sampson.
Thank you, Madam President. So that makes 4 amendments, all making the argument for freedom versus force, that have failed on a party line vote. And I'm disappointed by that, because I had hoped that there'd be some effort towards a bipartisan agreement on a policy initiative that is as vast and important as one that affects the entire public workforce of our state and many of our towns. I actually had one more amendment that I was going to call. And I'm not going to call the amendment, but I do want to have the conversation briefly because something occurred to me during this debate. I have been a proponent of a policy change in the state for the last several years and have submitted a bill each year to prohibit what is called supersedence, which is the process by which collective bargaining agreements can actually circumvent the laws that we pass in our state. I've always thought that this was a bad policy because the laws should apply to everyone, and there shouldn't be collective bargaining agreements that go outside of our system of laws and justice. However, considering the bill that is before us and the possibility that it may become law, and how it changes the weight on the scales in favor of one side of a collective bargaining agreement, I believe the only potential for the other side of that agreement to benefit or to put themselves in a better position is, in fact, supersedence, because they will be able to negotiate terms contrary to the bill that is before us in the collective bargaining agreement. And I would submit, Madam President, I fully expect that to happen. I believe that collective bargaining agreements going forward will contain provisions to supersede the legislation before us. And that's a good thing. So I'm not going to call the amendment on supersedence, and I'm going to have to wait and see if this bill becomes law to make a determination in the future whether I think that is a good policy decision for Connecticut or not. I'm sad that this bill is before us, Madam President. I genuinely am. I am very disappointed that it has come to this. I think that there has been I wouldn't use the word battle, but let's say a rivalry, essentially, through the history of politics in Connecticut and across the country on the subject of union labor and how municipal employers and the state negotiate these contracts. The concerns for the taxpayer, the concerns for the worker have played out. And while I might not have always agreed with the outcome in those cases, I always agreed with the notion that these were voluntary agreements and they were happening on a level playing field. The legislation before us, Madam President, I have noted many times during this conversation, but I cannot help by closing without saying that I believe this definitely unlevels that playing field and applies force to one side of the equation in a very unfair way. But I'm going to leave you with just what I think is most important to take away from this debate and this legislation, which is a reminder that this bill does not benefit employees in any way. If there's something I want people to hear and understand, it is that employees do not benefit. Not one point has been made during this entire conversation about how an employee will benefit directly from this policy becoming law. No one's going to receive more pay or benefits because of this law. The only thing that happens is that employees lose their choice in many respects. They lose their choice about whether or not their private information is provided to someone without their consent, their opt-in, or their informed consent. Despite my efforts to correct that, they lose their right to make a decision whether to participate in an orientation where they are very likely to be pressured to join the union. A choice they, again, should make on their own. They lose those rights. And even if you are the most ardent supporter of our collective bargaining system and our public sector employee unions across this state, you have to recognize that that system works because people choose to be involved. It is wrong to pass laws that say that employees do not have rights to make their own choices anymore. This bill's also anti-taxpayer, as I mentioned, because it is going to put more burdens on municipalities and the state in a way that will ultimately raise taxes. Not just directly either by the use of state facilities at taxpayer expense, but also in the potential of lawsuits and claims that arise from the conflicts in this legislation with existing law. We're about to take a significant vote on this bill, and I'm hopeful that since it's a Senate bill, it is debated as thoroughly in the House. And I'm begging my colleagues to think hard about the choice that they are making here, whether they support unions, whether they support employees, whether they are concerned for their municipal governments in the towns that they represent. They need to think hard about what is right and wrong, whether we should have freedom or force, Madam President. I will always choose freedom. Thank you, Madam President.
Thank you very much, Senator. Will you remark further? Will you remark further? Senator Champagne.